objections on the preliminary regime. The candidates were asked to produce material and proper justification for their stand. In total, 6,147 objections were received through online from 1721
Then
candidates.
earlier case, right? Then what happened? 15 questions. Right?
Yes, madam. Then we finally said, my lord, we are, as your lordships are aware, the judgments of the Supreme Court say one thing very clearly, that wherever the process of saying that the key is wrong by a long drawn argument, the benefit will go to the subject expert. Where it is palpably or demonstrably wrong, only those questions, my lord, we have concentrated on before the court, and we have zeroed down only on 6 questions, my lord, which are, I'll just give the numbers, my lord, for the purpose of demonstrating these questions, and I'll concentrate only on these questions. 41, 66, 79, 119, 119, and one more question, my lord, that was regarding that question number is 114. That means works out to, my lord, 41, 66, 79, 112, 114, and 119. These were the 6 questions, my lord, we concentrated before the learned single judge to say they were palpably and demonstrably wrong. Now, my lord, how the learned single judge deals with that, my lord, your lordship should get. So starting from page 47, I'll only read one way of dealing with the thing, and that repeats for all the 6 questions. I'll only take your lordship to page number 47, where, my lord, the learned single judge started dealing with the objections, etc. And this is what the learned single judge would say. We go to 41 at page 47. Match the following acts, rules in India with respect to their year of passing. Well, one question which I have to definitely tell at this stage is, my lord, there can't be a near answer for this. I will say why I said this sentence, my lord, while I go to the next thing. Forest Conservation Act, National Green Tribunal Act, Wildlife Protection Act, Hazardous Waste Management, Handling and Transboundary Movement, First Amendment Rules, Biological Diversity Act. The petitioner has raised an objection as it's found there. Learned Senior Counsel has contended that the question was about hazardous waste and not about hazardous and other waste management, handling and transboundary movement rules. And therefore, the answer, that is the year of passing of the rules, should have been 2009 and not 2016 as claimed by the commission in the final case. This was our contention. Disputing the same, the learned special government leader has contended.
2009 is not there at all.
Not there at all. So we were trying to say it's a question which has been wrongly framed. I'll take your lordships to the subject expert and what material we have placed. Whether the manner in which it is liable to be considered or not is what I will try to demonstrate.
So whether you have attempted this or not?
Well, according to the Public Service Commission, they have given marks for this also. For the first petitioner got a mark for this.
How many appellants are here?
5, my lord. So far as my case is concerned, 5. So far as the other appeal is concerned, it's 3.
5 and 3.
Yes,
8.
Yes.
So how many of you have qualified now?
2 of the petitioners in J. Sudhir's matter are qualified people. Rest of the people are not qualified.
Qualified for mates.
Concentrate on exam, no? Why all this?
Well, I am a person who is anyhow not qualified. And even qualified people are saying you can't say Telangana, what is the capital of Telangana is Rangareddy district cannot be an answer.
Huh?
Telangana, what is the capital of Telangana? If one were to ask the question, however much I am a group 1 officer or a probable group 1 officer, I can't say nearest point is Rangareddy. The learned single judge, the question will be twisted. So that what happens is instead of Hyderabad, it could be anything. Hyderabad also, because it is in Hyderabad, therefore Hyderabad will become the capital. If this is the understanding of the Public Service Commission and that has the approval of the court, in my humble submission, merit is zeroed. A person who writes a wrong answer will be meritorious person and he will rule the country for next 30 years.
1 minute. Hazardous waste management, handling, transboundary movement, First Amendment rules. When they have come?
My lord, I request your lordship, grateful to your lordship for putting the question straight. 3 documents will demonstrate that the answer is palpably wrong.
What is
First
that?
one is page 92, your lordship, 192 may kindly be looked into for 1 second, my lord. That was the material which we have filed to demonstrate that
How
the
many
question
lakhs
is wrong.
of students are writing this tomorrow's exam?
32,008, subject to what my learned friend would say.
31,000 approximately are writing for them.
31,000?
Yes, I give the exact figure, approximately
32,000.
31.
31,000.
31,000 out of 3 lakhs, 31,000.
$130 is the material.
When is the exam?
Monday onwards.
Huh?
Monday.
How many centers? Entire administration must have been
Yes, my lord. It's
set
all-
in process.
My lord, it's attack after attack, attack after attack. My lord, situation is, I don't even know which case I am arguing. That is situation that's happening.
That can come from my learned friend who is an expert in everything.
Yeah, trained by my friend.
He is an expert in everything. He can't say that only to create the public service commission, however new he may have been appointed for that.
What Mr. Rajశేఖర్ is saying that trained by you, but you are not
Well,
properly
who
trained.
am I to train and who is he to get trained? He is a Swayambhu. I respect him for that.
2011, after 2011, after formation of the state, until now,
Not even
not
single
a single,
notification.
not a single notification.
Not a single
13
notification.
years.
I am grateful to
Attack after attack.
No, actually, Shiva, one second.
Matter goes right up to Supreme Court and conducted a second mains, first in the history. And we have borrowed the tradition, and the new Telangana Public Service Commission doesn't seem to be an exception. 3 preliminaries conducted from 1950 first time. And we take pride in saying the 32,000 people. What about the 3 lakh people who have been thrown out because of your wrong key? No answer for that. And you keep saying merit will have to be. What is merit? If a person writes Kaitabad and he is selected, he is meritorious, who can double the country for the next 30 years.
How many marks you have got? On the
Well, let me not go. I have not gone into the nitty-gritties because I have missed by 2 or 3 marks. Let us take my.
No, let us take means you must also be clear. No? How many marks? How many?
Well, they don't have the. I don't think, subject again to what my learned friend may say, they don't have the habit of giving the merit list at this stage. At this stage, I don't think they will give. To the best of my knowledge of the Public Service Commission, whether the procedure is modified after the new regime, I do not know. But marks are normally given after the final examinations are there.
No, for this preliminary, this thing.
Cutoff they have not specified. 1 is to 5,000, God knows what's happening.
1 is to 50.
1 is to 50, I mean 1 is to 50. You have several things, the battle elsewhere.
How many posts are notified?
503 originally.
No, 560.
After 22 multiple, that has been cancelled and 560 given. Because again there is a change in the society. 22 was the original notification. This court said, reconduct the preliminary. Fairness demands they will have to do that. They went up to Supreme Court because this court specifically said, you are incapable of conducting the examination. Quote unquote, what the Honorable said, you, in spite of the importance, you do not know how to conduct the examination, is what the learned single judge said. This Honorable Court affirmed it without even modifying that. Being aggrieved by that, the erstwhile government went to Supreme Court. After the new government came, SLP withdrawn, notification cancelled. And they had before the single judge to say, we followed the judgment very meticulously. This is the following. And your lordships are also aware, to 503 posts originally given.
This time there is no leakage, nothing.
What
At
do you
least this time there is no leakage.
There is a
Leakage.
leakage in the system of the Public Service Commission.
No, but last time in fact to cancel only because of paper leakage something.
No, paper leakage, one thing. Then biometric I have not conducted.
That we have now.
Probable impersonation could be there, or it was not there. One of the standing counsel said before this honorable court saying that last time it was cancelled just because they are not given biometric. This is the attitude of the Public Service Commission. When we were trying to argue about some other matter, we commend the Public Service Commission for consistently misconducting the examinations. 2009 matter went up to Supreme Court. 2011 2 mains. 2022 3 sub preliminaries, and they are very keen to get a second mains also written because
In total there are 8, only 8 are there now applicants. Out of which 2 already qualified.
my lord, one person comes and tells this court that you have played a mischief on the entire selection process. Begging a question to myself, will 226 say, since you are only one person, your lordships are aware.
Shiva, just listen. Come concentrate on this page number, question number 41. Right?
Yeah, I am grateful to your lordship. My lord, since your lordship said right on the examination, my lord, I had to say it. Otherwise, I was only doing. Kindly go to 130 for one moment. Page 130. This is the material which we have created before them.
130.
Yes, my lord. There are two different rules. Hazardous waste rule. This is from the Central Pollution Bureau, not any Tom, Dick, Harry.
It is 2016, no Shiva. First Amendment.
1 minute, my lord. We will have to see the short title and the long title also. This is exactly what the subject experts were trying to do. Kindly see the first one. Hazardous and other waste management and transboundary movement rules 2016. Then go to the next one, my lord, at the bottom. After 21/7/22, your lordship should get another one. Hazardous waste management, handling and transboundary movement rules 2008. Now juxtapose this with the question, and the First Amendment rules have come in 2009. How do you call the question to be right at all?
Maybe that handling and all those things is more appropriate. Just listen. One minute, sir. Maybe handling and all those things appropriate is 2009. But handling is missing.
My lord, may I just give an example, my lord? I gave the same example before the court single judge also. Who wrote Merchant of Venice is a question. William Shakespeare is not available. Serena Williams is available. Could they say, anyhow William is there, therefore it is Serena Williams who wrote Merchant of Venice? Is that the right answer? Pardon me for using this example. Other two sets of rules are prepared. One saying X plus Y, one saying only X. You ask X, why don't you write Y, X plus Y answer? How is it?
If this kind of things are to be challenged, then no recruitment process will ever take place.
And again obliged to your lordship. Consistency, last of the thing being the latest, what is it, B.R. Ambedkar University, Agra versus Devarsnath, they never said this court doesn't have jurisdiction. They said you will have to do. Only thing is palpably wrong. Right from Samir Gupta.
How these objections were dealt by the expert?
No need of dealing it. Kindly see subject experts how they deal with. Well, that your lordship should get it. Page 192.
Yes.
And let me also share this, my lord, because my anguish will have to be shared with the court at least. What the respondent said before the court was, you will have to use your conscious head. This is what the predecessor of my learned friend said. I did not understand that. I went and checked up all things, whether an unconscious head will work at all. A group 1 officer must use conscious head, then how does others use their head? One thing. And second thing startling was, because you are a group 1 officer, 1 plus 1, if 2 is not available in the answer, you can't claim about it. So, if I am a group 1 officer or a prospective 1 attack, 1 plus 1 will become 3, or it can also become minus 1. Now, kindly see the subject expert, my lord, at 192. In supersession of hazardous waste management handling transboundary movement rules 2008, hazardous other waste management and transboundary rules 2006 have been issued by the Government of India. Therefore, question relates to hazardous and other waste rules. But the question doesn't talk about that. Then, hence the option 2016 has been correctly shown in the question. Since 2008 and 2009 are not mentioned as any of the options, there is absolutely no ambiguity for the candidate to answer the question. How? If I know Constitution of India was passed on 1950, and you talk about Constitution 101st Amendment, there is no confusion, is the subject expert. God save the subject expert. Then kindly see what he says. Moreover, when the given options are examined, only 4th option is correct. You have an act with a specific title, otherwise there is no need.
Shiva, issue is like this, Shiva. Now this is nothing but match the following.
Yes, madam.
If you answer A to D correctly, the 5th one option which is not answered will automatically have to apply for E.
That is why I gave that Kattabat example.
1 minute, sir. just listen. In match the following,
Correct.
5 questions are there.
Correct.
If you are able to match 4 correctly,
Fifth one will
automatically get matched.
Because matches the following questions, almost it will be either all right or 2 wrong.
Right, whatever it is.
2 will be wrong.
So suppose if you are confident of first 4 answers, if you match them correctly, the 5th is bound to
Fall into place.
fall into place. Whether you attempt it or you don't attempt it, that is automatic.
My lord, I'll say this, my lord. In an match the following question.
Correct.
Patna.
Fifth
Bihar.
one it did not match.
No,
That is
Patna, Bihar. No, that's not. You are
That is-
asking a specific question.
no, that is divine matching. 5th one will be divine
My
matching.
lord, divinity is what we need.
Yeah.
We don't need exam. We will throw a big ball. Wherever it goes, we'll pick up that one.
No,
Why
no.
have
No,
to
what-
start the exam?
Shiva, can I answer this, my lord?
Yes, you are. Personally,
My lord, I'm sorry, my lord. Your lordships are right in saying that 4 are matching. The 5th one automatically gets matched.
Hmm.
So that is a divine. But actually, my lord, your lordship may also kindly have a look at when 5th one is doubtful or something wrong with it. Then we'll get a doubt about all 4 whether we have matched it or right or wrong.
correct.
But
Next-
what is required?
Yes,
What is
yes,
required?
next, move on to the next question.
And
It
there
is
are
over.
6 options.
Let us not waste our time in this hazardous waste. Okay, move to next question.
My lord, if that waste is proved to be waste, there will be a wholesale thing in the waste list prepared by the Public Service
Okay,
Commission.
we'll come back to move on to 66, right?
No, my lord,
Do I
before.
think that the lordships are not convinced with what we have been saying in
No, no.
a specific act?
No,
No,
what we said. We have not expressed any opinion. We are asking you to move on to the next question.
No, then in that case, my lord, let me take 2 other things and then I'll move on, my lord. Kindly see, we have as a rejoinder, we have filed reply and rejoinder, we have filed 2 things. The Public Service Commission has filed the modified one. Kindly go to my reply at page 297 for one moment. What is the existing rule if they have asked? You will have to know what is supersession. What is the constitution? When was it passed? I am supposed to say only 1950. Kindly see page 297, my lord.
Yes.
We filed this. This rule was in fact available. This was superseded at a later point of time as by the subject. As a person who read the papers properly and the person who understood the short title properly, if he comes before the court and says, you do not know, this rule specifically says this and what you have done is wrong. Juxtapose 216 with 200 this thing, my lord. This is 216 is what they have filed. This is what I have filed. 220, your lordship may kindly see. This is what they said to prove me wrong. This is what I said to prove them wrong. Kindly examine both of them.
220.
Yes, my lord. 216, my lord. I'm really sorry for that. 216. This is the material to support that the subject expert was more than right. According to us, no. Kindly see short title preliminary. We are not concerned about that being superseded, etc. We are concerned about the short title. These rules may be called Hazardous and Other Waste Management Transboundary Movement Rules 2016. Now juxtapose it with 297. These rules may be called Hazardous Waste Management, Handling and Transboundary Movement Amendment Rules 2009. Now the question is, what is contained at 297 and not what is contained at 216? Then how do we call this to be a right answer at all?
No, this 297 is a amendment rules.
My lord, kindly see the question once again, my lord. I am sorry. Kindly see the question once again, my lord, which your lordship will get at 191. Subject experts question. Question has been extracted in the counter. 191 may kindly be looked into, my lord. I will deal only with D. Your lordship may see the question. I will read 297. If this is right, the answer given by them is wrong. These rules may be called Hazardous Waste Management, Handling and Transboundary Amendment Rules 2009. This is exactly the question. Now, what you are trying to say is superseded, etc. Have you ever written that this is the exact one which is binding now? Kindly see the question. Match the following act rules in India with respect to their year of passing.
Maybe Shiva, you might be having a case or no case. All those things will come later. But we are in the 11th hour. If we cancel the selection,
We got the judgment on 15th.
well, that is right. But you must not know. You must also understand how the unemployed youth are so frustrated. 1 minute. 1 minute. So many lakhs of people are on the streets. the entire unemployed youth are suffering with so. There is no recruitment since last 10 years. You must also understand.
Madam, I just respond to your last observation.
So let this go on.
Madam, I only say this. In 2011, why I am trying to
Because
this has got
lakhs of rupees have to be spent for conducting these type of examinations, because they'll have to take again biometrics and so many issues are there. It's not that simple.
Madam,
And
I'm not unaware of the difficulties.
no, that just listen. At the instance of 8 petitioners or repellents, of the 8, 2 are already qualified. At the instance of 6 people, can the recruitment be solved? Is a question. Try to
I
understand.
respond to your lordship's query in two aspects. Madam. First one is there are a lot of unemployed youth.
Correct.
After 11
Sir,
years,
one
we are
minute,
now
sir.
having a
Some
recruitment.
small issues will keep on happening. This is human error. Some leverage has to be given when recruitment to such large extent is being undertaken. Lakhs of people are writing, 3 lakhs, 4 lakhs. Because look, first group 1 exam, 5 lakhs people have written. Now second, it was cancelled on account of paper leakage. Look at lack of interest. So many unemployed youth have not even responded to the second time.
They found out the truth that this is not a true recruitment
Correct,
agency.
correct.
They have become biased.
Correct. Now 5 lakhs have not written. Only 3 lakhs have written. So look at the number of people getting attracted to this. Is
Madam, may I just now
because of so many frustrations are there in the society. You must also understand. The toughest part is it is unemployed youth who are hard hit. You must understand. Recruitment process should go on. The question of stalling recruitment process would not arise.
Now your lordship may permit me to respond to 3 queries which your lordship
Maybe whatever you are saying is, if we had time, we would have gone into all those things. But there is no time, Shiva.
Madam,
The
I
question
also
of
say
stalling.
this, madam. Your lordship may also say this.
Suppose if you succeed or something, at a later point of time, something can be done, saying that you create supernumerary posts or conduct some special recruitment drive or something like that. Otherwise, impossible to postpone these exams.
My lord, I now permit me to make
Just
one-
listen, sir. By just on the first time when the papers were cancelled and the exams were cancelled, so many people have committed suicides. You must understand. Again, biometrics. There is every possibility because Public Service Commission published this many number of candidates have appeared on the date of examination. Suddenly, after 14 days or 15 days, there
600 numbers more.
Then there was every possibility of impersonation or something. That's the reason we had to cancel, because 258 candidates were found to be more. When in a recruitment process of 503 vacancies, if 50% candidates, if they play fraud or whatever it is in the form of impersonation by not following biometrics, the purpose of recruiting 500 posts itself is defeated. That's the reason we had to cancel that. You must also understand
My
that.
lord, now let me say this.
Oh.
While your lordship's views on the matter may be absolutely correct from the broader perspective,
Naturally.
where your lordship
Because
is sitting. But kindly see this also, my lord. Your lordship cannot see only one view.
Correct.
Kindly see this also.
Correct.
Pardon me for using 2011 expression because this plays a very crucial role here.
Yes.
In 2011, the examination took place, went right up to the main examination, interviews were conducted. Day after tomorrow, they were to get the appointment orders. At that stage, AP Administrative Tribunal passed an order saying, let the doubtful questions be examined by the board, let the selections go on. Perhaps your lordship thought process was we should not thwart the recruitment process. Matters came before this court. When the matters came up before this court passed an interim order in one of the 2 petitions. Blissfully, unfortunately, myself and Sudhir were there. In my case, the court passed an interim order that since the matter needs to be looked into, no selection shall go on. Then the Honorable Court, as His Lordship Justice Subhash Reddy J then was, he said that the matter, 6 questions are definitely doubtful. Let the matter be placed before the UPSC. Till such time, hold your hands on. Not satisfied with this order, the Public Service Commission, persons who ought to have got the appointment but for the interim order passed by this, all went to the Supreme Court. So the persons who in the judicial, in the legal profession appeared for those selection people under the Public Service Commission, His Lordship Justice J. Chalmeshwar and Hemant Bhutiye on 7/10/2013 said this is not the way in which you will have to conduct, and directed the entire 146 questions, you will have 144 questions, prepare a merit list and reconduct the main examination. They conducted the main examination, and in the conducted main examination, 46% of the marks in history paper was wrong, admittedly by Public Service Commission itself. Again, we said that this is bad. Then the tribunal said we will delete that 46 marks and conduct. My learned friend Sudhir came before this court because Public Service Commission again came. We both were there again. My learned friend Sudhir said if
if your theory is to be accepted, or whatever has transpired in 2011 is to be accepted, then Public Service Commission can never conclude the recruitment process at all.
It can conclude proper care. Question is, your Lordship's order on the last occasion, what have your Lordship confirmed? Your Lordship may kindly see your Lordship Justice Madhavi Devi's order for one moment, and your Lordship confirmed it. Kindly see that. In light of this, we don't need to give an extra mileage for Public Service Commission after the specific finding of this honorable court in this court, which your Lordship affirmed it. Kindly look at 1 second, my lord, of the judgment rendered by Her Ladyship Madhavi Devi for one moment, my lord. That's filed along with the material papers immediately after your Lordship's order. But I'll take your Lordship first to learned single judge order, which starts at 111, but straight go to
Shiva. I think you must stop somewhere because we have to also dictate. 1 minute, just listen. 1 minute. We must dictate also. No? Suppose we don't know what is. Say, 1 minute, sir. What is passing through our mind? We have not made up our mind. We are open to everything. So suppose if you stop, then you must permit us to dictate. Maybe in your favor or may not be in favor.
No, I have.
The judges thinking aloud. Is that
suppose,
cannot be
suppose
something
no,
else,
no, no.
what your Lordship are
1
thinking
minute.
aloud.
1 minute. If you write a judgment, then only whether it will be postponed or not postponed will come out. No. If you continue to argue up to Monday, then what is that we can do? You must also understand. Sudhir is here to commence his arguments, and our bench is only up to 1:30. They again from 2:15 onwards, different benches, different combinations.
Normally, we will not argue to our heart's content. We will argue to the fact that.
You must also. We are just reminding. We are reminding you the time constraints. That's it.
Another 5 minutes at least I can get it subject to a lot of time.
Then Rajshekhar also has to reply, no?
No, for him, the job is now looking very easy, man.
No.
You have to just get up and sit down.
No.
At least as per thinking aloud system which is going on,
No.
my learned friend is blessed by appearing there. I wish I would be there, but nobody appoints me for that. Because I am not that privileged.
I wouldn't have to
System we are all there.
I don't know how.
Let me just put this minute. Now that we are able to understand the concern of the court towards those who got selected.
No.
I'm only saying. I'm not trying to say your Lordship the judge. I am using the word concern. I never said your Lordship decided it. I use my phrases very, very, very guardedly. I understand, my lord, appearing for any one of those persons among the 32,228, I would exactly think the way in which your Lordships are thinking. But I will only say one thing, my lord. If you have shut down people who otherwise should have been in, how is it a fair selection? That's the only thing I'll say. And then I leave it at that. Now, on the basis of it, my lord, also one more thing. You have a name. Can there be an airness to the name? And kindly see the learned single judge says it is after all a preliminary. If it is after all a preliminary, leakage need not have cancelled, biometric need not have cancelled. The learned single judge says it's after all a preliminary, there is other rounds of qualification. Who will get into the qualification? You throw me out at the beginning. Kindly see what the learned single judge says on that point, my lord. Can you call this to be after all a preliminary? It's make or mark. You don't allow me to enter into the college and you say what is there, you can go and join another college. While your admission policy is what I am questioning. The learned single judge says it's not the be all and end all of the matter. If preliminary is not the be all and end all of the matter, what is that? Questioning myself. I will have to participate and prove my merit. You don't even open the gate. And the learned single judge says judicial review is not permissible. After all, it is preliminary. He had learned that did not use after all. Pardon me for adding that. But the meaning is only that.
Sir, when did you file the writ petition date?
14th August. I mean, 1 minute. 14th August. 11th August 2024. Matter came up on 14th. If I remember right. I argued the matter on 14th.
Nice day.
I don't think I need to trouble your lordship. Your lordship will dictate the order after hearing my friends and the esteemed counsel for the standing here for this public service commission. But kindly see only this sentence I will read it over.
May make my subject.
1 minute, just 1 minute. I will only read this sentence to say the seriousness with which for preliminary is likely to be looked into. That's all. Nothing more, nothing less. Kindly go to page 53, madam. This cannot be the manner of deciding the fate of the people. That's the only last sentence I would say. Kindly go from 10 lines from the bottom, which says, in referred supra and being satisfied. 5 lines from the top, your lordship will get a sentence which starts with, with the line which begins with satisfied with the same. This court is of the view that contention of the commission that in an examination for recruitment to the top executive post, the candidates cannot expect a direct question. Not even a correct question. Direct question is what the court says, but our endeavor is it's a wrong question. Cannot be brushed aside. And the action of the respondents in posing twisted questions for making the most qualified persons, Serena Williams, William Shakespeare, to be eligible for further selection cannot be faulted with. Further, it is to be noted that preliminary examination is not the only criteria. So, if I have not failed, if I have failed in the preliminary examination, could I make it to the group 1 services? And this is how the learned single judge says, not the only criteria to group 1 services. Rather, it is only qualifying in nature. At the qualification stage, you test on a wrong paper. We have a public service commission who tests biology questions with the economics keyboard, and they say it's after all only a preliminary examination, therefore you don't need to worry about it. How do I participate in the further selection process?
Shiva, what do you say about this? Run Vijay Singh.
Run Vijay Singh, everything. If your lordship says argue on that, I will say. Every judgment says it does not mean that the power of the court is ousted. If they say Hyderabad is the capital of Telangana, we have not fortunately come to a stage that whatever they say, William Serena is the person who wrote Merchant of Venice, that's the last word. Fortunately, no Supreme Court said that. Ran Vijay Singh, Vikesh Kumar Gupta, everything talks in one sentence. If I am able to demonstrate that the answering of the subject expert is wrong, this court is not precluded from judiciary review.
1 minute, Shiva. Final key was published on 7/7/2024. It took almost 1 year for you to write.
24 to August will be only 30 days.
That's 1 month.
Yes, 1 month.
Why? You must be diligent enough.
Other day, my lord, I will quote your lordship's expression. These unemployed youth may not be easy for them to come to the court. 4 years, your lordships have been benevolent in saying, this is how we will have to look at it. 1 month. Your lordship may have to say that at the earliest.
They have to reach only up to Shiva's house. That's all.
Reaching Shiva according to them may be difficult. It may be easy to reach other persons. Because Shiva doesn't have a name board also on his office. It took time for them to come. Maybe 1 month period is not such a bad thing.
No.
They will have to collect material, try to persuade their
one minute, Shiva. They don't have to collect anything. In the objections itself, they must be available with them.
They need not know mathematics.
No, 1 minute.
Need not know history.
No, 1 minute, sir. This notification, which is published on 19/2/2024, has earmarked entire selection process when preliminary key will be published, when the preliminary examination will be conducted, when final exam will be conducted, and everything will be set out in that notification.
In 22 also it was set out.
Huh?
In 22 also it was set out. October 22.
What do it is?
There has been a change in the government. There is a new notification.
Correct, sir. Suppose you knew as on the date of notification that 19/2/2024, that is the second latest notification, that final examination is likely to be commenced from 21st October, no?
I don't think the notification has specified that. No. I will best of my knowledge, no. If they work with clockwise precision, why would we be troubling your lordship, my lord?
Rajshekhar, what is happening? UPSC follows so meticulously the
They don't
everything.
believe in anything, my lord. They are constitutional bodies. Lord, I think this is the last thing, my lord. At this stage, anyhow, your lordships are not of the view that this case will need to be dismissed. At best, it will be subject to final outcome. That's what your lordships are thinking aloud.
No,
For
we
the
have
purpose
not.
of
We have
Indian
not expressed anything, sir.
My lord, thinking aloud is not. Thinking aloud means it is not yet finalized. Your lordships have decided only dictation is something else.
Thinking will not produce any noise. It is a question of allowed.
My lord, your lordship's thinking will produce noise from this side. Whose thinking, your lordship's thinking is which paper, my lord, will decide who will make the noise.
One.
So Sudhir, particularly at 177.
Lord, may
Yes,
make
sir.
submission or before
Yes.
Rajshekhar.
No, I'm only answering Sudhir. I'm only answering the letter. Page 177.
Yes.
There are 1.2.
Para?
There are 1.2 at 177. Last date, application, edit option, downloading, alternate schedule of preliminary, schedule of
Yes.
we knew that the time is.
Yes. Sudhir, tell. Please
Lord,
proceed.
may. Well, I'll try to be as brief as possible.
Yes.
My Lord, first of all, my Lord, let me dispel the suggestion or view of your lordship's, my Lord, that a lot of money is spent, and so just my Lord, not that your lordships are not aware about that. My Lord, amount of money, my Lord, this court will never be carried away. Number one.
Nee,
Number
not in
two.
the money in the sense. In the form
No,
of making
spending of-
arrangement, conduct. No. Money,
Lot of
money,
man.
the money
manpower.
context, the money expression context was used in such a way that they'll have to make arrangements for
Correct.
conducting examinations
I
by
understand.
making
That's
so
what.
many. Right.
Lot of manpower, money, and all that will have to
Yes.
be
Yes,
arranged. Now your lordships are view, not even finalized. View is that it's better to go ahead with the process rather than wasting manpower and the finances taken out by the public service. In that case, Lord, I'm only trying to say that a thing has to be done in a particular manner, my Lord, or not at all. My Lord, just because they are doing a particular thing or in a wrong and illegal manner, my Lord, lordships will not give the judicial approval of that. Just because of they are doing it. My Lord, the reason why we come to lordships, my Lord, is because
Sudhir,
yes,
Sudhir,
Lord.
when did you file the writ petition? Date?
I filed on 31/7. Therefore, my Lord, the lordships may, I'm not saying lordships are carried away, but the lordship may not get swayed away on the ground that everything is done. And then, as a matter of fact, my Lord, it is at the fag end we understand, as the lordships have seen, my Lord, vacation intervene. It was directed to be posted on 14th, matter came up on 15th, the very got the
No,
order.
no, one minute,
And
Sudhir. 1 minute, Sudhir.
yes,
Of the three, two are qualified, right?
two are qualified.
Okay. When did you file your objections to this preliminary key?
My Lord, immediately within time we filed, my Lord. There is no dispute about that.
We means all of three of you or only one?
No,
Like,
only one person.
huh? How many
My Lord,
persons?
in both the cases, but only one person filed objections.
Only one person. Okay,
Two persons. In one case, in Shiva's case, and one person in my case.
okay.
My Lord, one for
What was,
consideration.
Sudhir, what was the order when the case has come up for the first time before the single judge? Has he referred the cases to any expert or not?
No, not at all. That my Lord, matter was adjourned at the behest of the Public Service Commission at least 2 to 3 times. Matter was heard when we insisted about vacancy. Matter was heard finally on the last day.
One
Matter was
minute,
reserved.
one minute, Sudhir.
Yes, my Lord.
Such type of cases on the first day itself, single judge ought to have referred these questions to the expert body, correct?
Correct.
And called for a report within a period of 2 weeks, correct?
Correct.
When such interim orders are not passed, then you must file appeals. and see
No,
that
no, no.
record is
No,
set
no,
straight.
no,
Because
no.
one minute, just
It was
listen.
just adjourned.
1
It was
minute.
just, yes,
1 minute today, just listen, have
yes,
patience, just
yes,
listen.
yes,
Page number 177, notification is issued specifying the preliminary examination, followed up by main examinations also in the month of September and October. Correct? Suppose
yes.
if these issues are not addressed immediately, then the entire recruitment process will be stalled, no sir. So some effort should be done.
It has to
No.
be stalled either 1
No.
month before, 2 months before, or 1 day before. Because
Uh.
a thing that has to be done in a particular manner, but just your lordships also knows
Rajshekhar,
there was
it should have been like this. The single judge should have referred these cases to some university, the disputed questions,
Yes.
and called
Yes.
for a report.
yes,
Then entire issue would have been resolved within
Yes.
then and there itself.
that is
Now,
exactly
people
what
just keep on asking time for counters, and judges are
Yes.
not able to decide cases.
That's
And this is
correct.
the problem. The entire recruitment
How am I-
process.
absolutely, Lord. Now, Lord, matter is
No, it is
adjourned
not.
for-
It is not. It is not for the courts to say whether this answer is correct or that answer is correct. It is a body of, because we are
But
not.
it is not in thin air, my lord.
Uh.
Total 6,147 objections were received.
Possibility, sir.
So kindly appreciate
Suppose if
this
someone, no,
situation.
when somebody is,
appreciate
1 minute, just listen. If somebody is doubting those things, then the only thing is it should be referred to independent body of experts.
Doubting at a person who is qualified, they kindly appreciate this. 1 and 3 in Mr. Sudhir's matter, they qualified. And 3 made objections, it is of no relevance. 1 and 2 did not make objections. See, kindly see the situation. And Mr. Siva's case, only one of them made objections. And challenge after participation.
No, please don't argue, Rajshekhar. I have not completed.
Yes, Sudhir, please proceed. Another 5
So,
3
I'm-
minutes are there.
Sorry, my lord, I need some time, my lord, because it's not that I've just only challenged the key issue. The lordships are, till now, my lord, Shiva discussed about it, and lordships are looking at it only from the key issue.
Correct.
I'm only trying to dispel lordship's view in the beginning stage that, my lord, that so many things have happened. Lordship, my lord, there hua magar durust hua. Everything has to be done in a proper manner.
Correct.
And, my lord, because 2 times they have not done it properly, kindly appreciate, my lord, kindly take my note, this thing, by my booklet. My lord, kindly take that. And then in that, it was issued in 2022, it was cancelled because they should have conducted. Why they have not conducted is they have cancelled first preliminary examination because it was not properly done. Similar issue, my lord, just because it is a second or third, it doesn't mean that it has to happen. My lord, whether 10 times or 15 times, what is to be done has to be done in a proper manner. If your lordship sees that it is not being done properly, lordships will definitely interfere. My lord, learned single judge permitted the Public Service Commission to file counters and then gave 2-3 times, my lord, adjournment. My lord, if we challenge, as lordships rightly said, my lord, if we come for it appeal, lordships will definitely say, obviously say, my lord, may not be saying, but obviously, my lord, our experience is, matter is seized of the learned single judge, why don't you go back?
No.
And
Please never-
no interim direction, no interim directions are rejected. It's not as if, my lord, interim directions are rejected, therefore we can come.
Okay, what is the other point? What is
No,
the
no. Now, therefore, my lord, just 30 seconds, I'll come to my actual ground. Money, my lord, aspirants, your lordships have said, my lord, now 3 lakh people are outside. We are also aspirants, my lord. Persons who are fighting, my lord, are 3 lakhs or 4 lakhs. Now only 30,000 people are writing. My lord, according to me, 30,000 or 20,000 who should write are those who are entitled in law. Those who are not entitled in law just because they are there because of a wrong procedure cannot be, my lord, the only aspirants. We are also aspirants. And, my lord, lordships also.
What is the other issue?
No, other issue, my lord, I have raised is that first of all, cancellation, your lordships may kindly see, your lordships, the judgment of Justice Madhavi Devi was to reconduct. Kindly appreciate one was cancelled by Public Service Commission. The second preliminary examination was cancelled.
When
by
it was cancelled? When it was cancelled?
Second was cancelled first was cancelled, my lord, on 17/3/2023 because of the
17?
leakage.
17?
2023.
17/3?
2023 on their own, Public Service Commission at page 130.
Right, next.
Then what? Then second examination was conducted. They have not cancelled the notification. They have conducted a fresh second preliminary examination. That was found to be incorrect, my lord, at page 134. It says that page 150, Justice Madhavi Devi, what she said, Lordship kindly see. Can they go beyond the judgment of this honorable court?
Second preliminary examination was conducted when? Date.
Second preliminary examination.
That is 19 June. 19 June 23.
23.
Yes.
That was cancelled when by way of a judgment.
By way of a judgment, page 134.
Then
On
that
20
notification when you have cancelled?
No, 1 second, my lord. 1 second, my lord. The Justice Madhavi Devi's judgment was 23/9/2023.
Today,
For a minute,
you must conclude, otherwise our time is over. Suppose you walk away without dictating anything, you know, your dictation will become infectious.
mine is first case, my lord. Today, I had the opportunity of the whole of the day, but because of the other matter to be
You
taken,
agreed
my
for
lord,
that, Sudhir. You have agreed for that.
I have agreed. That doesn't mean, my lord, that the lordships would cut me
Again,
out on grounds.
Just because you have entertained a lunch motion, it doesn't mean that we should forego our lunch.
No, I'm not. None of us should, my lord. I can understand that, but because of the urgency and the enormity of the matter,
No problem. We can forego our lunch also. Please proceed. Right.
No. What I'm saying, my lord, is that the lordships will rejoin, my lord, at 2:15. I've done.
No. We have got some other bench. That's the reason. Today we.
No, that's not, my lord. The lordships knows, my lord. Lordships can accommodate that. The
No
lordships can
problem. You can proceed, Sudhir. No issues. We are willing to
No.
sit and hear you. Right.
correct.
You
Lord.
want to
I do not want a hungry judge or to keep on, my lord. I think it would be appropriate, my lord, by request
No,
to be.
1 minute. Sudhir, you can't force us to eat, right?
Anyhow, my lord, eating is not possible at all.
Anyhow, you people are eating us.
And your lordships have a habit of not eating regularly also. He doesn't know it.
Please.
My lord, if your lordships gives at least, my lord, we need at least 10 minutes, my lord, if it's okay.
No problem, Sudhir. Please proceed.
Yes, my lord. Now, my lord, I'm obliged, deeply obliged. My lord, the order passed by Justice Madhavi Devi is to reconduct the examination,
Yes.
not to cancel the notification.
Correct.
That was affirmed by lordships, my lord, by the judgment, my lord, rendered on 27/9/2023.
Correct.
Not satisfied with that, because they wanted to sustain the second preliminary examination and the notification, they went before the Supreme Court. And Supreme Court did not obviously grant an interim direction or anything, or directions, and found that there will be in the soup. Therefore, my lord, on 19/2/2024, matter was withdrawn. SLP was withdrawn, making your lordship's judgment, my lord, final, which is nothing but affirming the judgment of Justice Madhavi Devi, which says conduct examination,
Correct.
not cancellation. But
Then
on
what
19
happened? Then what happened?
On 19/2/24, my lord, not only they have withdrawn the the SLP, on the same day, new notification is issued.
Have you challenged that new notification?
That is exactly. Now, what I'm saying is that cancellation, my lord, has no power. It goes to the root of the matter.
But having
Where is
participated in the 1 minute, sir. Having participated in the preliminary examination, how can you challenge that notification now? Just
That's
because you have not
exact-
qualified. That will,
Correct.
Ashok Kumar will apply, no?
My lord, the judgments have been cited before the learned single judge, saying that appropriate, reprobate will not apply in matters where it goes to the root of the matter. And I relied upon Mita Sai's case, my lord, that was not considered. The judgments, my lord, unless and until you participate, you cannot. My lord, once the matter goes to the root of the matter about the cancellation, where is the question of, my lord, when there is no estoppel. The concept of hot and cold and estoppel will not arise in a matters where the matter is constitutionally invalid. The whole, but they have, when the court says reconduct the examination, what right they have to cancel the examination, my lord? And what is the basis? Kindly see the cancellation. What is the reason given? Kindly see the cancellation, my lord, at page 176.
So here it could be like this. Earlier, 503 vacancies were notified. Now 560 posts are notified. That's the reason they have to issue a fresh notification. Perhaps that could
No,
be one
they
of
don't. No. When the court says conduct examination, you have to confine it only to 503, or you can add 60. My lord, the reason they say is that
No.
my lord, every day, one second,
service.
my lord.
1 minute, Sudhir. You are
Yes.
also appearing for service commission, right? Just listen. Service commission can increase or decrease the
Correct.
number of
They-
power they have got.
Even cancel.
Cancel on.
That's my case. That is my case. They can increase. There is no necessity for cancellation. They can add this 60. They could have added this 60 because what the reason for cancellation, my lord, the reason for cancellation, as mentioned in the counted affidavits, is 60 more vacancies came. Every 1 month, my lord, there will be vacancies. That doesn't mean that you cancel. You can add addendum.
Very
You
well.
can add addendum, or you can say that we have right to add. They have been adding or deleting.
Any other
So therefore,
content? Any other
now,
content?
and most important thing is the reason for cancellation, Lord Speaker, 176 page. They are not saying that we want to add some more vacancies. If they want to add some more vacancies, that is not the ground.
Correct.
What they say is in public interest. At page 176, what public interest is involved? But is it public interest to cancel a validly given notification? But just because preliminary examination is not properly being conducted, there is no need for cancellation. More so when the court directed to conduct examination. It amounts to contempt actually. Is it not contemptuous having taken, my lord, the matter to Supreme Court,
No,
withdrawing
one
it?
minute. One minute, Sudhir.
Yes.
Just because High Court has said they have got inherent power of cancelling it.
Yes.
As long
There
as
is
they
no
have-
power. Correct, Lord. First of all, there is no power because you are only an agent. Lord, government has not mentioned. Government never gave which rule, which provision of the regulations, Lord, provide them to cancel a notification. Notification is not on their own. No, 1 second, my lord. Notification is not issued on their own. It is notification is not issued for Public Service Commission employees. Issued by the at the indent of the government. When the government asks you to do a particular thing and you have started it, you cannot
14.1.
stop it. You cannot stop it. You have no right. Government has not told you, nor you have taken concurrence or ratification. And the reason, my lord, there is no reason, contrary to the directions of this court. Number 3, you have no power. There is no power at all. And the reason given, my lord, for any administrative action to do, there has to be a proper reason material. What is the material? Are you, my lord, is it not a political thing? Because there is a change of government, you want to cancel it. Supreme Court has said this cannot be done. Cancellation, I filed a judgment, my lord, which is before lordships. Cancellation cannot be done at the whims and fancies of the authorities.
Where is
Without
it? Which page?
my lord,
Which
the
page is-
judgment of the Supreme Court is before lordships, my lord, at page 481. Not, I have given several judgments, my lord. I have given a note saying that the cancellation cannot be done by the recruiting agency, just like at the drop of a hat.
4?
81.
4. Amarnath Singh, my lord, 481.
Read, Sudhir. Yes.
My lord, I don't want trouble, your lordships. Kindly go to page 494. My lord, after discussing about various judgments, about the right
Yes.
of authority to cancel,
Where you are reading, Sudhir?
in the almost similar circumstances, court has set aside the order of cancellation of the recruitment by order dated so and so, in so and so. I have taken a view after discussing all the rulings of the point that the action of the respondents in that case cancelling the selection process was contrary to the provisions of the particular law. Both these authorities 45 by me in this judgment. In view of the findings that he so-and-so has tapped the entire recruitment process in light vein without realizing the implications of his orders, and that the order was passed on no founding and in unreasonable and irrational manner. The impeded order of cancellation of the entire recruitment process must therefore perish on the above ground. Since the order of the scrapping of the recruitment process,
Sudhir, they were cancelled on 19/2. 1 minute.
yes,
And issued the next fresh recruitment on 19/2 itself. So what is the
Same
prejudice cost to you?
same day, my lord.
Hey, what is
No,
the
no.
prejudice? No, 1 minute. What is the prejudice it has been cost to you? The same
My lord,
notification.
I'll answer.
Is there any selection process different in the first notification and second notification?
No,
Nothing.
no, there is. I'll come to that. That's my second point. But before that, Lord, the prejudice is, Lord, you cannot keep on making us to write examination after examinations and cancellation, my Lord. You cannot play with our lives. My Lord, this is what has happened in 2011. 2011, my Lord, they are trying to say 10 years you have not conducted, 10 years you have not conducted is the reason for you to conduct it properly. 2011, you failed it utterly. Now also you failed it twice. Court says conduct preliminary examination. You want to say always, I'll go back to square one. Not a prejudice, not a prejudice for me. Now the prejudice is you have added, kindly see, my Lord, second notification, persons who are eligible on 1/7/2024, 1st July 24, are also made eligible for 503 vacancies. Who must have been only in the degree first year. Those who are not eligible as on the date of notification for the earlier notification, 1/7/2022, they are all made eligible now. Making unequal.
One minute, Sudhir. Whenever
Yes.
public employment is taken up, it should be the interest of employer or selecting authority that more number of people are attracted so that the best of best talent is recruited. Right?
Correct. Let them let them give a once again in 2025 more number of candidates will come. Matter of the issue, my Lord, is that when 503 vacancies were notified, there will be millions of graduates in the state, but only, my Lord, 3 lakhs or 4 lakhs applied. So
Sudhir, just Sudhir, try to understand. Just because at the instance of 8 persons, of 8
No.
who are qualified, just listen, Sudhir.
Correct. Yeah, I
6
understand.
persons, at the instance of 6 persons, the group 1, which is a jinx kind of an examination, which is sought to be conducted from so many years. Every time some legal flaw or something, it has been cancelled, it has been rectified. So somewhere we must stop, Sudhir. Otherwise, what
Correct.
happens is,
No, exactly.
1 minute, Sudhir. 1 minute, Sudhir. 7/7/2024 is the final key which was published. Then I can understand, because the notification itself said so, that final exam will be conducted in the month of September and October. That means if you come to the courts, then you must get the remedy immediately. If you don't get the remedy, then recruitment process cannot be stalled. That's the point.
My Lord, the query that the issue that your lordships are laying only 2 persons or 1 person. My Lord, even in 2011, the matter that went up to Supreme Court and we fought. I went to before the Supreme Court and my Lord, we fought before the Justice Subhash Reddy said, what is all this? Give it to UPSC. APPSC carried the matter to the Honorable Supreme Court. Supreme Court said no tribunal, no High Court. We are dealing it under 142. 6 questions were found to be basically wrong. Delete them.
That is Supreme Court 141. It can do anything. We can't do that.
That's what. No. What I'm saying, my Lord, is that you Lord, the High Court has referred the matter to expert committee. They gave a committee report, my Lord, saying this is all correct.
That is the reason we are. That is the reason we are telling you.
One second, my Lord. Your lordships can still now do it. Now, my Lord, it's not, my Lord, it's a matter of 1 day or 1 month or 2 months. 10 years are over. So within 1 month or 2 months, my Lord, you cannot blame. we cannot blame you lordships. I cannot be blamed if the Public Service Commission, which is a constitutional body, which is expected to do properly, but every time, my lord, they cannot pick up 150 questions and give proper answers. Now, that is about the key. My lord, your lordships, I heard only one case. There are so many cases, my lord, we will not also be bringing, my lord, baseless and useless issues before lordships. We have seen several questions, all of them we have rendered them not good enough. And then where there is an issue of consideration, where your lordships can look into and then refer the matter to experts only we brought. Your lordships have heard only about that acts and matching. There are other questions also which are palpably wrong.
No.
Matter should have been referred to experts.
We never prevented anybody from arguing any case.
Correct.
He was argued only
I know that.
one question. No?
I know that.
Ready to argue 66, your lordship said we'll have to dictate. I thought the first case would be sufficient to say they did not even know and understand about the short title. 6 questions I have raised. Since your lordship said we'll dictate judgment, why should I come in the way? I sat down.
No,
All
Shiva,
the
1
6
second.
questions are
My lord,
probably
your lord,
wrong. But
one
your
second,
lordship said we will have to dictate. I said okay.
my lord, there is
And
one.
I only said 15 questions. I have raised
Shiva.
6. I am ready to argue.
Yes.
My lord, as a matter of fact, my lord, this requires your lordships, my lord, just because of the time lag or just because one or two your lordships rose, my lord, this I said before the single judge also, I am repeating it. My lord, Keshwananda Bharate judgment was rendered by only one person, my lord, Keshwananda Bharate.
Yes.
But your lordship, my lord, it's not a question of how many. It's not a question of quantity, my lord, it's a question of quality.
One person
My lord,
can
if-
become a class.
No,
This is what
therefore-
Supreme Court said in Re-Special Court Bill Act.
In that case, constitutional points were raised. Sudhir. Yes, this is only a, one minute.
Conducting a selection for 30 long years of bureaucracy. This is not a constitutional crisis which the public.
My lord, public service
is creating.
commission.
What else could be a constitutional question? My lord,
Shiva, you
come
had
forward,
it.
pass acts.
Shiva,
They will
please.
pass rules.
Shiva,
They
please.
will assist the government. They will try to implement the policies. These people will do it. That this is
Shiva,
more
please.
important than a constitutional question because 30 years they are going to be the safeguards of the constitution. These people.
One must also understand, Shiva. How many people will be becoming age bar? That also will-
What about your lordships have taken one thing? What about the petitioners who have come before? What about those persons who have suffered a wrong key? They are also belonging to the same society. They have not come from an alien society. But for your action, I would have been there. These are also persons unemployed. These are also persons attempting for the past over 5 to 6 years.
Shiva,
We will
Shiva,
answer.
please.
Yes, because I have come, they will have to be protected. May not be the right way of looking at it.
Yes, Sudhir. Yes,
Shiva, please don't eat up in my time, please. Please.
I think we both are going together, Sujay. I'm not.
I know,
sure
but-
we are not eating each other.
You had your mouth full, let me have mine. My lord, I'm only trying to say, my lord, your lordships may not get swayed away by the number of people. Your lordships may not get swayed away by the time lag because we are not concerned. My lord, your lordships will have to see the legality. This is the only court where I feel legal points only will be seen, not other points. My lord, legally I'm saying, how can they cancel it? How can they cancel it? On what ground?
Yes, any other contingent, Sudhir?
And this your lordships have said was, I have raised the second issue, my lord. Your lordships may for a minute have a look at that the first ground is cancellation cannot be done contrary to the judgment and without any basis and without any power. So it goes to the root of the matter.
Correct.
Now, my lord, the question of approbate, reprobate will not arise. I have filed that also. Mita Sai also I have filed before lordship. There are several judgments I cited before. The law and single judge did not non-suit me on the ground of approbate, reprobate because I have cited so many. Mita Sai also of the Supreme Court judgment I filed. Supreme
Which
Court
page?
said,
Which
in
page?
my lord, I'll take your lordships, my lord. That is page 503.
Yes. Where are them? You can go and have. Where are replacement?
503, my lord.
Yes, please proceed.
But Supreme Court said, Lord, I don't want to trouble your lordships at this time. the issue raised was also hot and cold there. But the Honorable Supreme Court said, in matters of this nature, you have to participate. If you do not participate, what right you will have? First of all.
Right. Any other contention?
Now, in that view of the matter, the learned civil judge did not go into the matter of that, but went into the matter. None of my contentions, other than looking into the 6 questions, were considered, and they were simply set aside on the ground of delay. But the question of delay, the learned civil judge also says the matter was issued 6 months back. It is not absolutely delay, but in the matters of this nature, it is a delay. But the question of delay would not arise in the matter of once the question goes to the root of the matter about the cancellation and the power. In the counter also they have not mentioned about what power they have.
Any other points?
There, the next issue, because of this, the second issue I've raised, is assuming that the cancellation is valid. You should have made 503 vacancies only for the earlier candidates. You should not have expanded the competition. It should have been notified as an addendum or separately, or even now you can do it, because persons who are not eligible as on the date of earlier notification, who had tried twice, their rights are taken away, and then some 2 lakhs people are joined now.
Correct.
They cannot join, they have to compete only with for that 60 because they are added now. So therefore, unequals are made equals. You can still do it now. You have to do that, even if the examination is going ahead. Can be gone ahead. Now the third issue, my lord, ST reservation is increased from 6% to 10% in between the 2 notifications, just before cancellation.
No, that is the submitted before other court case. Second court case.
No. I'm not saying that it is wrong. I'm only trying to say you cannot make it applicable to 503 vacancies. I'm not challenging that GO. The GO challenge is before another bench. I am not on that. I am only trying to say this GO 33 was issued just before the second notification could be made applicable only for the 60 vacancies, not for all the vacancies. The vacancies that are there earlier.
33 is dated?
Not
39, 2022. 30th September 2022.
2022.
1-3.
And between the 2 examinations.
13th September 2022. 13/9/2022. No, I stand corrected. 30th September.
30th September
30th September 2022.
No, therefore, my lord, on the ground of allowing 60 persons or these persons for that, and then also extending 33 GO for all the 503 vacancies which were already issued, you should have. There is no necessity for fresh notification. You have added an addendum and then called for applications for the 60. This has not been done. Fourth issue, my lord. Fourth issue.
Yes.
The notification says no extension of time will be given for applications beyond the time. At page 189, 7.12, specifically says we will not entertain even a minute. That's what they are trying to say. But then they have been extended by 2 more days. They themselves, they are also page 180, which is part of the notification.
189.
Yes, bro. Which is page 189, para 7.12.
Yes.
This is their own notification. They have no respect for their own notification. They have no respect for merit, no respect for procedure. No correspondence will be entertained to accept applications, extend the date after closing the date of submission of applications.
Correct.
Now, whereas they have extended it at page 230. By which 30 to 40,000 people who have joined. Is it I can do whatever I like? Is it just because they are a constitutional body? Is there no end for their illegalities? 230 extension, and the reason now given, my lord, kindly see, my lord, people have requested. Also, I am requesting tomorrow. I'll ask for the post of deputy collector. Why can't you give? If requests are accepted, 2:30. What is the reason given, my lord? There is no reason. And now they come up with the reason saying that some people have had some technical glitch. Therefore, we have entertained.
Yes. Any other issue? That's all.
My lord, on this extension itself, my lord, would show that the persons who have applied after that extension time, after the time, are not entitled to participate. They are now not only participated, they are also part of the selection process.
Correct. Any other
Now,
point?
my lord, all these things would go to show that this is not the way that the whole process should be conducted. And my lord, had it been conducted fairly, my lord, there is no necessity for so many litigations. They themselves have demonstrated from their conduct that twice they failed in their thing. But one more time doesn't make a difference. Let them reconduct the examination by excluding by making it correct, Lord, as to these vacancies. 60 vacancies have to be treated separately because they have come subsequently.
Very well, Sudhir, will consider.
And then, Lord, only one key answer, Lord, one answer, Your Lordship, I take. Lord, that is with regard to constitutional course. That will be very easy for lordships to, because that is dealing with our own subject. Not we don't have to even go for the experts or. Lord, kindly go to the judgment, Lord. One question with regard to page 36 of the internal page, Lord, judgment, Lord, single judgment. Question number 119. Question number 119. The question is, which of the following articles of Indian Constitution is not related to economic safeguards provided to the scheduled caste? So, not related to. Lord, whereas learned civil constituents contended that as Article 23 and 24 never speak of economic safeguards provided to the scheduled caste, the question itself suffers from ambiguity. Disputing the same, learned government trader has contended that as per the subject expert committee, Article 23, my lord, if your lordship sees 23-24, that is not pertaining to special caste. It is pertaining to general. So how can the 23-24 also, 23, 24 and 46 from part of the economic safeguard? 46 is understandable. 23-24 has no connection with the safeguards of the economic status of scheduled caste. But therefore, my lord, the answer is wrongly given. According to them, all three, 23, 24 and 46. Now it should have been not. Which of the following article of the Indian Constitution is not related to? Then, my lord, there would have been only one.
Right.
Now, my lord, in view of that, this is, my lord, glaring and then palpable reasons or questions. My lord, your lordships, with respect, my lord, may not get swayed away by the time or the number. I am only trying to say, Lord, what has to be done properly has to be done. Your lordship knows the Taylor versus Taylor. A thing has to be done in a particular manner, has to be done in that manner or not at all. Just because you are going ahead, my lord, the lordships are also concerned. The lordships may also show the concern for the people who are otherwise entitled to be in the fray. And it's not a case, Lord, of blowing hot and cold, because persons who are qualified and who are not qualified, all of them are before lordships. And we are not responsible for the delay because we filed it in July. I filed it in July. And my lord, the matter was dragged on by the Public Service Commission. This is the trick of the Public Service Commission. Every time they do all sorts of mistakes and mischiefs, and then my lord come forward and then say that we need time and all that. Finally, get it to the close, and then now everything is arranged. People are writing, but this has to be stopped. And lordship may kindly see, my lord, the history also speaks by itself. They have done it earlier. They are doing it now. I'm only trying to say. I'm only trying to say, refer the matter to experts. Hold it on.
Please consider that, Sudhir. Yes.
But while I may not match the eloquence and volume of my friends, my lord, I'll be very brief, my lord, in my submissions. My lord, Mr. Sudhir's clients, my lord, petitioner 1 and 3, they have qualified. My respectful submission is having qualified, my lord, to say the notification to be set aside. In my respectful submission is not maintainable at all. And my lord, the only third petitioner had made objections, and none of Mr. Siva's clients, my lord, have made objections. No. I'm sorry, I stand corrected. Petition number 1, except him, and that gentleman answered question number 41 correctly, got a mark for it. Kindly see the situation in which we are placed. So much is argued on 41. One petitioner got a mark for that. But my respectful submission is that having participated in the process, challenge after participation, as your lordship has rightly pointed out, my lord, is impermissible in law. My lord, I will not trouble with the judgments. Your lordship has only said, my lord, the citation order, sorry. JP, where is that? That is Ranjan Kumar, 2014, 16 SCC, 187, paragraphs 14 and 15.
What does it say?
What it says, well, having participated with your eyes open, it says, the next submission which has been presented before us is when the respondents had appeared in the interview knowing fully well the process. They could not have resigned later on, taking a somersault, saying that the procedure as adopted by the department was vitiated. Then, my lord, Madanlal is extracted. It is now well settled that if a candidate takes a calculated chance and appears at the interview, then only because the result of the interview is not palatable to him, he cannot turn around and subsequently contend that the process of interview was unfair or the selection committee was not properly constituted. Lord, I'll just pass on this judgment.
Ashok Kumar is sufficient. One judgment is sufficient.
Yes, my lord. Ashok Kumar also, my lord, is there. The learned judge has extracted that, my lord.
Page 54.
Page 43, my lord, of the judgment. Internal page 43 of the judgment. Paragraphs 11 at page 43. The basic issue that was addressed by the division bench was that the appellants, having participated in the fresh round of selection, could not be permitted to assail the process once they are page 40, internal page 43 of the judgment.
Yes.
Okay, right. Any other point?
My lord, secondly, my lord, the question, my lord, whether which answer is right, how the question should have been framed, my lord, my reciprocal submission is a classic case where the examinee wants to examine the examiner. My lord, they want to lay down how the question paper should be framed. They want to lay down who is to be selected. My lord, the terms of selection, the process of selection, answers, everything is dictated by them. Unfortunately, the Constitution doesn't provide for such a thing. Lordship may kindly appreciate the Public Service Commission is vested with the responsibility of recruitment, not the examinees. They cannot come forward and say, you conduct the exam in this particular way. You have to declare the key in this particular way. This is the right answer to this question. But my reciprocal submission is Ranvijay Singh, which the learned single judge has extracted in the judgment. They said, hands off, courts cannot go into this question at all. And neither myself or your lordships are, my lord, equipped to answer such questions. As, for example, Mr. Sudhir argued, my lord, the question with respect to economic safeguards of scheduled castes and scheduled tribes. Kindly see, my lord, Article 23 talks about prohibition of trafficking human beings. Well, it applies to all human beings, including scheduled tribes. And forced labor and bonded labor of children in factories, it applies to everybody.
Question is specifically for.
Please, Sudhir, allow me to complete. So therefore, my lord, there will be no, and as your lordship have said, that if we go on dissecting every question, my lord, out of 3 lakhs, we could get 31,000 people. Now, at the instance of 6 people, we go on dissecting each question, there will be, my lord, 2,70,000 more different answers to these questions who did not get qualified at all. And we found out, my lord, these 6,175 objections have been considered. The expert committee gave its recommendations. 2 questions were deleted, 2 marks were added to everybody.
Hello. How many objections?
If commission is above all, why ask for objections at all?
No, number of 6,175 objections in all.
6,000?
6,175.
175.
And my lord, one petitioner in Mr. Shiva's matter and petitioners 1 and 3 and third petitioner in Mr. Sudhir's matter alone made objections. They did not make objections at all before the expert committee. They had an option of doing that. Only 2 of them made, and they both got, my lord, the correct answer to 41. They both got marks also. Yes, my lord. Secondly, my lord, the cancellation, my lord, is challenged. My lord, 3 things occurred, my lord, between the cancellation of the previous examination. One, my lord, is, as your lordship has pointed out, GOMS number 33 dated 39/2022, increasing the reservation for scheduled tribes from 6 to 10%, which necessitated, my lord, change of the situation. Secondly, my lord, GOMS 29 dated 8/2/2024 was issued. GOMS number 29 dated 8/2/2024 was issued. 8 February 2024 was issued, but amending the process of selection from preliminary to mains. But following the rule of reservation under 2222A, my lord, we have specifically said that 1:50 shall be called with respect to each category. My lord, that is also subject matter of challenge before the division bench. Yesterday that was refused. My lord, they said we are not going to interfere. And matter is at that stage, my lord, the no interim orders are passed with respect to challenge in GOMS number 29. 50? GOMS number 29, my lord, was challenged in a batch of writ petitions before the division bench.
1:50.
1:50.
In each category.
In each category. What we said was that, my lord, that we will first of all take 1:50 from the entire pool, and then, my lord, we will see whether each category is satisfied. If it is not satisfied, we'll go down below and then collect for that particular category. That process, my lord, was challenged.
We are ensuring that the 1:50.
We were ensuring in all categories we wanted to ensure. My lord, this necessitated, and also the fact that new posts were, my lord, required to be filled up.
Anything else?
These 3 aspects, my lord, necessitated cancellation. Therefore, my lord, I respectfully pray the Honorable Court to dismiss the application for grant of stay. Yes, my lord, only one thing, my lord, more than 90% people have downloaded the hall tickets, my lord. Exam, it's all ready, my lord, to start from Monday for a whole week. It's not a case for interference, my lord. This is my respectful submission.
Yes, that's all.
Just add, my lord, in 30 seconds or 1 minute. My lord, GO 29 aspect has nothing to do with the present issue. Now the issue is, my lord, my friends cannot trivialize, my lord, the issue saying that the constitutional body and then we are dictating. My lord, we are not dictating. If you do it properly, where is the necessity and why is that your lordships will interfere? Your lordships have interfered also. So just because they are a constitutional body, my lord, if I have a right to fix the question and answers, then why are you asking for objections? There is no necessity for objection. That means there is a participation of us, citizens. And then a constitutional body cannot be unconstitutional to say that I'll do whatever I like and every other constitutional body like you have to keep quiet. And then other thing, my lord, only 1%, 2%.
One minute.
One aspect.
We have received objections in respect of how many questions?
Yes, my lord, that's also. Yes, yes.
$6,175 objections we have received.
Yes, yes.
Pertaining to what is the total?
I'll just know.
Which were there in the examination?
Yes, yes. My lord, from 1,721 candidates, objections were received. 6,147 objections were received.
In respect of how
In
many
respect of
questions?
number of questions, my lord, I'll just know. I'll just know. Let my friend complete, my lord, I'll just know.
As admitted by them, 2 of them are, 3 of them, 2 or 3 have been deleted. But that itself shows, my lord, that they are not doing it properly. My lord, what about the experts, my lord? Can they not properly frame questions and answers? Where is the necessity for every time to delete 10 questions, 5 questions, 20 questions? My lord, is it not failure on the part of the constitutional body? Should it not be properly done? And my lord, 1 mark will make or mar a candidate's future. As I was explaining the other day before the single judge, my lord, he will become a deputy collector ultimately, or he might have to do some small business, my lord, or open a pawn shop. My lord, it's all 1 mark. It's a rat race. And then you cannot take questions and answers in such a light manner. But if there is no process of objections, that means those 3 questions would have been continued. That means you would have called the persons who are not eligible and excluded persons who are eligible. But 1 mark makes all the difference. Now, Lordship can appreciate, but it's not a question of whether how many raised, how many objections, whether it is right or wrong. Your Lordships will see the legality of the question and whether it should be referred to an expert committee. Their experts committee, my lord, are expertised in bungling the whole thing. That is what is the expertise they have developed in. That is what has been proved, my lord, not in this case. Your Lordships have seen not only Group 1 is cancelled, the preliminary was cancelled, so many examinations were cancelled, and every examination is before Lordships. And they have the audacity to say we are constitutional body, we can do whatever we like. No, nobody can do whatever we like in this country when there is a rule of law. Lordships will be guardians. Lordships will be the guardians of constitutional law. Our constitutional right to be selected properly under Article 14 and 16 has been violated.
Okay,
Not one, hundreds.
I'll give only 2 sentences reply.
Anyhow, good night, Sudhir.
My lord,
Good night. Yes, please.
what
No,
good
no,
time,
no,
my
no, no.
my is now, my lord, it is almost 5 o'clock in the morning.
Then good
Hey,
morning.
good morning.
Good morning.
Go for a walk.
Now,
Well,
the answer to-
I cannot go for a walk. It's too chilly. It's too cold. Anyway, my lord, I'm deeply obliged, my lord. The Lordships delayed your Lordship's lunch, and we only request, my lord, request Lordships to do justice, and then we are only.
Just conclude, Shiva. There are 2 benches. There are 2 benches, maybe small benches. After that, we'll
I
assemble
only
and try to
make 1
dictate order.
sentence in reply, my lord, not more than that.
Correct.
So the statement made by my learned friend was, Constitution does not provide for an examinee to examine the examiner. This is quote unquote my learned friend, subject to corrections which he may do at the appropriate time. Question is, a constitution says, Constitution was prepared in 70, nobody should question it. I don't think that's Constitution. This is number 1. Second thing is, my learned friend, in his busy schedule,
Judicial
perhaps he
cannot
did
be
not
taken
read runway chasing itself. For his convenience and for the convenience of the court, let me say this. Para 18 says this. A complete hands-off or no interference approach was neither suggested in Mukesh Thakur, nor has it been suggested in any other decision.
Where you are reading, sir? Which page?
Ranvijay Singh, para 18.
Which page?
That is the Ranvijay Singh citation is, my lord, 2018, volume 2 SEC, volume 2 SEC, page number, ఇంకోటి కూడా ఉంది 2 కాపీలు తీసుకున్నాం. Ranvijay Singh.
Which page?
That page number will be 363, my lord.
Which paragraph?
Para 18. I'll read only these 4 sentences, nothing more, my lord.
Then what page is it?
It says this, my lord.
Which
Yeah,
paragraph?
para 18. 363, it starts placitum G. A complete hands-off or no interference approach, may I read on, my lord?
Yes.
Was neither suggested in Mukesh Thakur, nor has it been suggested in any other decision of this court. The case law developed over the years admit of interference in the results of an examination, but in rare and exceptional situations and to a very limited extent. This limited extent is, if you do not know that the capital of Hyderabad is Telangana is not Hyderabad, this court will only have to say Hyderabad is the right answer. If that is the understanding of the constitutional body, God save the merit which they pick up. We are not dissecting the answer. We are saying the examiner doesn't know what is the capital of Telangana. That's all, my lord. to dismiss the SLP. On 15th, 14th, they knew that the judgment was being delivered on 14th. They forced the hall tickets on 14th in such a way that people out of anxiety, we understand the students also. And then they come up 90 people and 90% have already downloaded. Yes, you have forced it that way. It doesn't lie in the mouth of the person who does a wrong. Still say I am a constitutional body, nobody can correct me. Fortunately, Rang Vijay, which my learned friend referred, itself says not a hands-off policy. And it was reiterated in 2023 SCC Online 970 B.R. Ambedkar versus Devarshanal.
Sir,
That's all, my lord.
preliminary examination consisted of two papers or one paper?
Only one paper, but entire 150 were objected. Everybody made objections.
In respect of all.
All questions, objections were made. Though petitioners, majority of them did not avail of that opportunity, they wanted a different forum though.
Along with the application, you must also ask for question paper. What kind of questions you must ask? That would be.
Not that.
What is the In fact, what should be given is an option should be given to the examinee. Please tell us how to conduct exam.
No, because when you do not know, we have to tell you, no? Because you are not able to conduct, which is your history, we have to tell you, or the court has
Yes,
to tell.
yes.
If only, and then keep on saying, Lord, let me just say this, Lord, if 2 plus 2 is equal to 4 and nobody has raised objection, and then they say 2 plus 2 is equal to 5, can it not be raised?
Sorry for keeping you waiting.
Can this court not look into?
Bless
I am grateful for your license for extending your lunch time, my lord. I am deeply obliged for the patient audience and bearing with order.
Obliged.
We'll continue assemble after those two benches
Yes.
and dictate the order.
Bless.
Grateful, your lord.
What is the case here? Sir, 1 minute. Tribunal has set aside the charge memo. You have came here and filed writ petition. Got suspended the tribunal's order. That means charge memo is revived. You should have concluded in disciplinary proceeding. Then? Huh? What? Ramarao, just follow the case. Charge memo is issued. For the same allegations, he was tried in a criminal case. He was acquitted in a criminal case. So charge memo was pending after acquittal. That person came and challenged that charge memo before tribunal. Tribunal has set aside the charge memo, saying that once he is acquitted in a criminal case, the question of keeping these disciplinary proceedings is bad. Allowed the way. You came and challenged that orders by way of a writ petition. Got suspended the tribunal's order. That means charge memo gets revived. So that suspension took place in 2004. We are in 24. For 20 long years, you could not conclude the charge memo. What is it now you will do? That's what we said. Understood or not? Correct. Thank you. When you can review it, we are not able to understand. Senior, got the point? Maybe, sir. Who refused? I mean, who asked you to not to conduct charge memo? After 20 years of suspension of.
Impersonation. He got certificate of another lady and joined in fact. The plot will not even on the last day of retirement also we can take action. The underground probably the use. What we should.
But opportunity given to you in the form of suspension of tribunal judgment.
The principle only is sufficient, but what we should is everything. The delay cannot be attributed to government, it is the point of that. That's the only issue.
Okay,
If it's some other respondent, as Rohit pointed out, this delay may come in the way of issues.
is it your case you are likely to conclude that this is a charge memo? No.
In fact, the inquiry is completed because of some reason.
No charge memo is, no inquiry is concluded. No. Huh?
I vaguely remember that it's a case of absolute fraud.
But one submission, my lord, as your lordship has rightly stated, what made them to not conclude in all these 20 years, my lord, 20 long years they were silent. And now after my lord, filing the contempt application, they come up with the review application. After filing the contempt application, they came up with the review, my lord. After 20 long years, they could have done it earlier only. When your lordship has suspended the orders, then itself they could have taken this action.
Okay. Review IA 1 of 2023 is filed to review the orders passed by this court in petition number 10730 of 2020, 2004 dated 22/10/2022. Third, GP for Home and Umarani, counsel for the respondent. Yes, Chapani, what are the grounds? Huh? What is it only? Radhe Jepal. Counsel for the review petitioner had contended that the respondent has indulged in grave misconduct and criminal proceedings were also initiated, though the respondent was acquitted of the criminal charge. But the inquiry and no, the departmental proceedings were also initiated by issuing a charge memo, and the respondent has approved the administrative tribunal by filing OA number 7861 of 1998 challenging the charge memo, and the tribunal by orders dated 22/1/2004 was pleased to set aside the charge memo on the ground that the respondent is acquitted of the criminal charge. Agreed by the same, agreed by the same, a writ petition was preferred, and this honorable court was pleased to dismiss the writ petition by the orders dated. Agreed by the same, the review petitioners have preferred writ petition number 10730 of 2004, and this honorable court was pleased to dismiss the writ petition by the orders dated 20th October 2022 without appreciating any of the contentions raised by the review petition. Counsel for the review petition has contended as the respondent has impersonated, that's an allegation, impersonated qualified after issuance of original notification dated 26/4/2022, thereby marring the chances of appellants for selections. The counsel for the appellant had further contended that when original notification was issued on 26/4/2022, there was no increase of percentage of reservation in favor of ST candidates. Now, the percentage of reservation for ST candidates has been increased from 7% to 6% to 10%, by GMS number 33 dated 30th September 2022. If only the earlier notification was followed, the ST reservation was confined only to 6%. With the issuance of fresh notification, the ST category candidates are being benefited by 4% of reservations in favor of them. The counsel for the appellants has further contended, as per the original notification dated 26/4/2022, only few set of people were eligible. With the issuance of a fresh notification on 19/2/2024, many candidates who were not eligible as on the date of earlier notification have become eligible, and the competition for the Group 1 post has increased multifold. The counsel for the any other contention, Sudhir? Not able to hear. Right. Yes.
Malad, 503 vacancies. Malad, not only 6 to 10, Malad, but I have also stated by virtue of that increase in 10, more number of STs are called for mains, and then that many number are excluded, OCs.
Correct.
That's one thing. And so
counsel for the appellant has further contended that the revised procedure is also being followed by the Service Commission in pursuant to GMS number 29 dated 8/2/2024, wherein the Service Commission is ensuring that for final examinations for each category of candidates, for each category, the Service Commission is calling candidates in the ratio of 1:50. Thereby, the ST candidates are being more called with the enhanced reservation in favor of them, thereby denying selection opportunities to other category candidates. The counsel for the appellant further contended that the original selection should have been confined to 503 posts only, and in respect of 60 vacancies which were added in the new notification dated 19/2/2024, separate recruitment process should have been initiated, wherein only persons who have become eligible for those posts can be considered. But because of the cancellation of earlier notification, the Service Commission had enlarged the scope of the participation of candidates who were initially not eligible
and making that's why making. Yeah, I'm sorry.
Who were not eligible are made eligible with the issuance of second notification, fresh notification on 19/2/2024. The counsel for the appellants has further contended that the preliminary examination was conducted on 9/6/2024, and all the appellants have participated in the preliminary examination, and the provisional key was published by the Public Service Commission on 13/6/2024, inviting objections to the preliminary key, and the time limit was prescribed up to 17/6/2024, and two of the appellants have submitted their objections in respect of 15 questions, and the objection submitted to the appellants was not considered by the expert body, and the final key was published on 7/7/2024. The counsel for the appellant had contended that the final key finalized by the expert committee in respect of question number 41, 46, 79, 112, 114 and 119 is concerned. The answer as finalized by the expert committee is erroneous, and 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 to demonstrate the same, the counsel for the appellant had relied upon (299) 97, Shiva? 297, correct? Relied upon and contended that the answer furnished by the expert body to question number 41, which reads as follows. Page 47, question number 41. In respect of the answer furnished by the expert committee is 216 when it comes to hazardous waste, brackets to management, handling and transboundary movement, brackets closed, first amendment rules is concerned is totally incorrect. As far as hazardous waste, brackets to management, handling and transboundary movement, brackets closed, first amendment rules is concerned, have been framed in 2009. To strengthen their argument, they have filed the Ministry of Environment and Forest notification dated 21st July 2009. A perusal of the same would disclose that the rules were framed in 21st July 2009 but not 2016. Likewise, they have contended that in respect of several other questions also, the answer finalized by the expert committee was found to be incorrect and agreed by the answers as finalized by the expert committee. The appellants have approached this honorable court by filing writ petition number 21239 and 22320 of 2024, and the learned single judge was pleased to dismiss the writ petitions by way of a common order dated 15th October 2024 without appreciating any of the contentions raised by the appellants. Counsel for the appellant had contended that when the answer furnished by the expert body is demonstrably wrong, then courts can intervene and refer the disputed questions to independent expert body. The learned single judge ought to have referred these cases to an independent expert body instead of dismissing the writ petition. The counsel for the appellants had contended that except for two appellants, all the other appellants were not qualified to participate in the final examinations, final main examination. Had the Public Service Commission conducted the exams in a transparent and fair manner, the appellants would have secured a place to participate in the final main examination. Any other contention, Shiva?
My lord, for the interim order, we have demonstrated only one question, my lord. For the purpose of interim order.
On final order, sir. We are passing final orders. No question of interim order.
No, interim order can be rejected, my lord, but
No,
final
no.
argument, then we will have to perhaps argue whether all the 6 questions are right or wrong, at least, if not anything else.
We have heard so much, Shiva. What is
My lord,
No, we began our dictation.
my lord, I leave it to your
No,
lordship.
just listen, Shiva. We began our dictation. Both these writ appeals are being disposed of by way of a common order. For convenience, writ appeal number so are here under discussed.
Then, my lord, I'd only suggest one thing, my lord. The other objections which we have raised regarding other questions as contained in the writ petition will also be dealt with by this, your lordship may say. Otherwise, what happens, my lord, it will be only one question that we have debated.
No, just follow the court, no? That allow us to fill up those gaps.
Since your lordship asked if this is the only contention, my lord, I thought I'll have to be doubly safe. Because whether it is in our favor or against that,
No,
this may...
one minute, Shiva. What happens if writ appeals are kept pending? Nothing, no useful.
No, my lord, your
No, no.
lordship, for the purpose of balance of convenience may not interfere with that. That doesn't mean to say the examination will go on and that a person who is not meritorious will get it. All
Exactly.
the cases where the examinations have been asked to be reheld may have been only in the final order, not at the interlocutory stage. Pending
And-
finalization of that, kindly ask them to stay their hands off is what we have asked. So,
No, in 2011, Shiva, one second, Shiva. In 2011 also, my lord, the prelims was over, mains were over, matter went up to Supreme Court. Supreme
You
Court
can- now also
redo the.
No, now also you can go to the Supreme Court.
my lord,
No, I am not.
we have a constitutional remedy to
What?
go to the highest court, my lord. Everybody may be aware of that. But the question is, my lord, if your lordships are, what is it, limiting the debate only to 41, other questions are worse than this. We thought an act, if they don't understand, they will not understand anything. Therefore, I took act and that my learned took the constitution.
The counsel for the appellant had contended it. The final main examinations are scheduled to be held on 21st October 2024. If the service commission is permitted to go ahead with the final main examinations, then the appellants would put to irreparable loss and hardships. Therefore, the final main examination be postponed till such time that the service commission refers the disputed questions to an expert body, to an expert independent body, and only after independent expert body furnishes a report, then let the service commission undertake the next process of selection, that is conduct final main examination. Any other arguments, sir? That's all? Right. The counsel appearing for the respondent had contended it.
But I'm sorry, my lord. I've also argued about that extension of time, my lord. Your lordship, can you
Okay.
recall?
The counsel for the opponents has further contended that as per the notification dated 19/2/2024, it was made very clear that the last date for submission of application will not be extended under any circumstances, and contrary to the said clause, the service commission has extended the last date of submitting applications, which would mean that the service commission itself is not following its own is not complying its own conditions in the notification, thereby by extending the last date for submitting applications, more number of candidates have participated in the group 1 selections, thereby delaying the opportunity, thereby enlarging the competition, and which would be detrimental to the persons who have applied to the original notification dated 26/4/2022. Right? Therefore, appropriate orders be passed in the writ appeal by postponing the final main examinations, which is scheduled to be held on 21st October 2024, and further direct the service commission to refer the 6 disputed questions, that is question number 41, 61, 66, 79, 112, 114 and 119 to independent body of experts, and let the independent body of experts examine the disputed questions, and after obtaining opinion from the independent body of experts, let the Public Service Commission proceed with the next stage of recruitment process, that is conducting final main examination. The counsel appearing for the respondents had contended that the Service Commission has got every power to cancel, modify the notification, which 180 ఏమన్నారు కదండి
18.1.
18 point, which page 187? 187 I think.
Wait.
It is a notification.
Yes. Notification is at page 177.
177 page.
One 197 is the clause 18.1. 197. In Mr. Sudhir's file. That is WA 1188.
Well, that's a new notification. Cancellation has been done for the old notification. The tracing should be from the old notification, not
That
from
is
the
in
new.
106.
The Standing Counsel for the Commission had contended that the notification dated 19/2/2024 itself deals with power to cancel para 18 of the said notification. The Commission decision shall be final, and in the said para 18, it was made clear that the Service Commission can withdraw, cancel the notification at any time by duly.
But I'm sorry,
concerned.
I'm sorry, my lord. That withdraw oblique cancel is in the new notification. What has been cancelled is the old notification, so they have to draw from the old notification.
Here in the old notification.
Page 106 para 18.
There is no word for cancel. They have added now because they cannot cancel. And just because they have mentioned it there doesn't mean that they have power. Power has to be traced to some statute, not to the notification.
Right. The Commission has got.
Only says withdraw. There is no cancel there.
Withdraw is nothing but cancellation.
No, then there is no necessity for adding because they have understood there is a withdraw and
Para 13 of the notification dated 26/4/2022. Para 18 of the said notification empowers the Public Service Commission to alter, modify, or withdraw the notification at any time. And that decision of the Commission shall be final. In exercise of that power only, the Service Commission has cancelled the earlier notification dated 26/4/2022 on 19/2/2022. On the very same day, a new notification is issued, that is notification number 2 of 2024 for the post of 563 vacancies. The Service Commission had to cancel the earlier notification in order to include 60 new vacancies in the Group 1 cadre, and in order to implement GOMS number 33 dated 39/2022, wherein there was a change policy of the state government, wherein the state has enhanced the reservation in favor of scheduled tribes from 6% to 10%, and also in order to ensure that each category is adequately represented in the form of 1:50 ratio, in order to implement GOMS number 29 dated 8/2/2024. The counsel for the respondent has further contended that the appellants, having participated in the selection process, and the appellants have not challenged the orders of cancellation of earlier notification, and issuance of new notification number 2 of 2024 on 19/2/2024, and the petitioners and the appellants have participated in the selection process, and after participating in the selection process after participating in the preliminary examination, having not been qualified, the appellants cannot turn around and challenge the
Two qualified. Yes.
cannot challenge the selection process, and in fact, two of the appellants are already qualified for the main examinations. The counsel for the respondents has further contended this. The Service Commission has published the preliminary key on 13/6/2024, inviting all the candidates to file objections, and the time limit prescribed for filing objection was also up to 17/6/2024, and two of the appellants have filed their objections, and it is not that the Service Commission has finalized the answers to the disputed questions on its own. The Service Commission has referred the objections to an expert body, and based upon the opinion of expert body only, the Commission has finalized the answers, finalized the key answers by publishing it on 7/7/2024. Therefore, a transparent method was adopted by the Public Service Commission by referring the disputed questions to an expert body. Only upon the opinion of expert body only, the answers were finalized. The counsel for the respondents has further contended it. Nearly 31,000 and odd candidates are likely to participate in the final main examinations, which are scheduled to be held on 21st October 2015. That is 2 days from today, and the candidates have also 90% of the candidates have already downloaded their hall tickets. Postponing the examination at this point of time may not be feasible. The entire administration has been involved in order to conduct smooth final examination. Postponing the final main examination would cause lot of prejudice to several thousands of candidates. That too at an instance of 6 appellants. 2 of the appellants are already qualified to participate in the final main examination. Therefore, stalling the examination process, which is marked by several controversies in the past. 2 preliminary examinations were conducted, and the Public Service Commission could not conclude the recruitment process consequent upon paper leakage at the first instance, and by not following biometrics in the second instance. If the recruitment process is stalled, several unemployed youth will be put to irreparable loss and hardship. Therefore, the learned single judge has rightly not interfered with the case, and rightly dismissed the writ petitions. Therefore, there are no merits. Writ appeals are liable to be dismissed. Yes, any other contention?
The extension of 2 days was done because there was a glitch in the payment gateway of the bank, because of which we received representation that time has to be extended. Therefore, 2 days had to be extended because there was a payment glitch.
The respondents has further contended that the last date for submission of application had to be extended as there was technical glitch while accepting the application forms, in order to ensure that everybody gets an opportunity to submit their applications. As a last indulgence, time was extended by 2 days only, on the representations of several candidates.
Yes.
Therefore, there are no merits. Writ appeals are liable to be dismissed. Any other contention?
That's all.
Sunil, any other contention?
Ranvijay Singh, dear Lord, may kindly consider.
Judgment in the
Very well. The question whether courts can go into the question of question and answers and all, the learned single judge put it squarely on that. That is why, we are pressing. That's all.
Shiva.
I have nothing more to add, my lord.
this court, having considered the rival submissions made by the parties, has considered you. The Public Service Commission has finalized the key answers based upon expert body's report. It is not that the Public Service Commission has finalized the key answer on its own. Therefore, and as far as the contention of the appellants, that this court should examine with proofs whether the final key answer as finalized by the Public Service Commission is right or not is concerned. This court cannot go into that aspect as this court is not expertise to examine as to whether which answer is the correct answer. When once expert body has finalized the key, then it has to be left open to the experts only. It is not for the courts to finalize the key answers. As far as the contention that the
Lord, I'm sorry.
as far as
I'm sorry. We never contended that your lordships have to finalize the key. We are only contending that there is some palpable mistakes.
one minute, sir. You are trying to demonstrate 141 question. You are trying to show 297 page number and say that this answer is correct to section question number 41. We can't decide that. That's what we said.
No, our case is not for lordships to decide. Our case is to refer the matter because there is a doubt. Because we are not experts. We are not saying that lordships sit as an expert. That is not our case, nor my friend Shiva, if I am not wrong. We are only trying to say,
where is the affidavit? 65.
We not argued, my lord, that we lordships should finalize.
Correct.
Once there is a palpable mistake, my lord, lordships will see, my lord, if there is a glaring mistake, matter will be referred. Unlike Supreme Court, where the last occasion where they have done it. Because courts are saying if there is a mistake, matter has to be referred. There is no bar.
87,
right?
para 43 is the only ground.
Right.
Page 87, para 43 of the affidavit of Mr. Sudhir. Page 87.
Read.
Ground D and para 43. This is the only place, my lord, where they say.
Where is the prayer?
Prayer, no, my lord, I am saying the averment your lordship wanted to know with respect
Not
to.
averment. Where is the prayer?
Prayer, my lord, is page 90. Page 90. From 89 onwards, my lord, it's a 3-page prayer starting from 88.
Read.
But call for the records pertaining to web note dated 19/2/24 through which earlier notification number 4 of 22 dated 26/4/22 was cancelled, and the consequential second notification number 2 of 24 dated 19/2/24 and set them aside as bad, illegal, unfair, unsustainable, unconstitutional, besides being contrary to public interest and contrary to the directions of this honorable court in WP so and so as affirmed by the division bench in writ appeal so and so, and consequently direct the first respondent PSC
There
to
is no
conduct.
question. We have not raised anything about disputed questions, Sudhir. You have not challenged anything.
I mentioned in para E.
Prayer lo lekunda immandi meeru.
Prayer lo,
Right.
I'm telling.
1 minute, Shiva. Where is your prayer, Shiva?
Para E of my prayer also talks about clause.
My petition starts, my lord, at page number 168. Your lordship may kindly see.
66.
Consequently, cancel the entire preliminary examination and hold the same duly taking care in both setting the question paper and finalizing the key, or in the alternative, direct that the key be revised if necessary by referring to some independent body like Union Public Service Commission, and further take action including conducting the main examination only after this exercise is done.
What is the main interim relief, Shiva?
In the interim relief, I said suspend it till such time the question is decided.
Huh?
The interim relief in the writ petition is what my lords are asking?
Yes.
Yes, my lord. That your lordship should get at page number 87. Pending disposal of the writ petition, it is prayed that this honorable court in the interest of justice be pleased to direct the first respondent to stay all further proceedings in pursuance of the results declared on 17/7/2024.
We have understood.
Grateful to your lordship.
You should have asked interim prayer to refer it to independent expert body. And this kind of stay business will not help anyone.
My lord, if the Public Service Commission was so magnanimous in doing it.
1 minute. You should have sought an interim prayer before the single judge to refer to independent body.
Correct, my lord.
Thank you. Great.
Correct. Hindsight advantages will be there. I can't, then the objection would be, main prayer, interim prayer are same. Your lordships have got rich experience at the bar also, my lord, which
Those
says,
days are gone,
if I
Shiva.
they are
Those
not
days-
gone, my lord, they have gone bad to worse, if I may say so with great respect.
At least before this
Previously, the main prayer, interim relief was the sheet anchor of every respondent.
Yes.
We have not
22nd
moved miles from that.
22nd court, I am aware of.
Yes, we have not moved
Yes.
away, miles away from that,
Yes,
my lord.
yes.
We are still in the respondent attitude is the same. The entire system may have changed. Councils may have become very wise, but the attitude of the respondents
We are
goes
not-
back.
No, we are vanishing. Still, system is continuing.
But
with what to do.
we all owe a duty to bring it back, though not to the past glory, at least to some glory. Our effort is only that. It has gone, therefore let us also leave it, my lord. That's a fatalist theory. And I am sure your lordships do not contribute to that. It is going back, let us give a hand at best. We may go down along with
You are
them.
trying to understand. We are not interfering for one reason. You have understood. You must also look from our angle also,
My lord,
because
I first, your lordships are aware. When we were in the office, my lord, we were only thinking about respondent and on what grounds the court will reject our case. I still continue that practice.
no. Don't
I still continue that practice. I start from the negatives case. My learned friend Rajshekar must have told me 100 times that you are a devil's advocate.
No,
When
no.
he tries to discuss with my case, I would say only respondents how the courts will react. My learned friend would say I am a devil's advocate. I continue and I am proud to be a devil's advocate because I know what your armor is. I know what your weapons are. I try to train it with that. I may fail miserably as
No.
usual.
Why do you think that you are failed?
No, my lord, I am
just
failing.
listen. One
One
minute.
second, my lord, I am not failing as an advocate.
No.
I may fail to get the relief which my client said because always there are more than one perspective to a problem. Every court and every person need not accept what the other man says. But my only endeavor is you should have asked that prayer, my lord, may be a difficult situation in the current standard, quote unquote 25. Nothing more, my lord. That's all. That and nothing more than that. 22.
Right.
But adding to what Shiva said, Lord, I am not going into those finer aspects. But I only say that the prayer of ours is to, because there are so many problems, to set aside the preliminary examination. First of all, either cancellation should be cancelled, go back to the original thing, or at least set right all these things and then do it. Therefore, we are not asking you to when we are mentioning the
AC meeting also.
We are really sorry,
No
my
issues.
lord.
No issues.
We will not, at least I will not interrupt your lordship. Since your lordship asked a question, I respect it. Otherwise, I was just sitting silent.
Himra Sandhya. A perusal of the prayer made in writ petition number writ petition number 21239 of 2024 is concerned. There is no challenge to the disputed questions and finalizing the key. And as far as the prayer in writ petition number 22320 of 2024 is concerned, no doubt there is a prayer, there is a final prayer that the disputed questions should be referred to an independent expert body, but that relief is being asked in the main prayer instead of as an interim relief. Had the petition appellants have sought an interim relief initially to refer the disputed questions to an independent expert body, then perhaps the learned single judge could have explored the possibility of referring the disputed questions to an independent expert body. But the interim relief sought by the petitioner appellants in the said writ petition is staying off all further proceedings, which will not serve anybody's purpose. The council, a perusal of the notification further makes it very clear. A perusal of the notification dated 19/2/2024 would make it clear that the entire schedule of selections were already stated, wherein the preliminary examination were supposed to be held in the month of June, and the main examinations were scheduled to be held in September and October 2024. When once the calendar, when the schedule of selection process has been set out in the notification, the question of postponing the final examination, which are scheduled to be held on 21st October 2024, would not arise, and stalling the examination, which is scheduled to be held in another 2 days, would cause inconvenience to several thousands of students who are likely to take up examinations. A perusal of the and this court can take a judicial note of the fact that the Service Commission has issued the notification way back in 2022, and in spite of 2 years, in spite of several attempts being made to conduct the selections, they have ended up in disputes, and finally the preliminary examination was conducted in the month of June 2024, for which the next process of selection is final examinations, which is scheduled to be held on 21st October 2024. Therefore, this court is not inclined to postpone the final examinations, which are scheduled to be held on 21st October 2024. And as far as the contention of the appellants in writ appeal number 1188 of 2024 is concerned, that they are challenging the notification dated 19/2/2024 on the ground that the Service Commission could not have cancelled its earlier notification and issued a fresh notification. To this contention, the appellants are having participated in the selection process, having participated in the preliminary examination, and having been unsuccessful in the said selections, the appellants cannot turn around and challenge the notification dated 19/2/2024. If the appellants were agreed of issuance of fresh notification on 19/2/2024, they should have challenged the notification. They could not have challenged after the results published in the preliminary examination. Therefore, the judgment rendered by the Honorable Supreme Court in, what is it, Ashok Kumar? What is it?
Yes.
Ashok Kumar would definitely attract, wherein the Honorable Supreme Court has categorically held that persons who have
Ashok Kumar versus State of Bihar, my lord, 2017, 4 SCC 357.
wherein the Honorable Supreme Court has held that persons who participate in the selection process cannot turn around and challenge the very same selection. Therefore, this court is not inclined to interfere with the orders passed by the learned single judge. Both the writ appeals fails accordingly their dismissal.
One aspect, my lord, your lordship said appellants in 1188 having participated and not qualified. In fact, 1 and 3 qualified, my lord. Appellant 1 and 3 qualified, only 2 did not qualify. Your lordship just now said, yes, my lord.
The appellants.
So therefore, judgment of Ashok Kumar, all that is applicable only for those who are not participated.
Why
failed,
would anybody
and
who has qualified challenge the
There is
notice?
also delay, sir.
So why not? I am not a person failed. I am qualified.
Deeply obliged, my lord.
Asking for time. If the final exams are postponed, the candidates who would be participating would be put to irreparable loss, and the entire administration has already taken steps to conduct the final examinations in a smooth way, and stalling the final examinations would cause irreparable loss to scores of individuals, that too at the instance of 6 unsuccessful candidates.
Bless, deeply blessed. Single level Raj. इसको पूछो, सुबह